Hi, everyone. Thank you so much for joining today's Visas.AI attorney collab. Today is September 29th, and we're joined with some awesome attorneys and non attorneys, including myself. Why don't we kick off today's uh, slash collab with asking Zoe how her week has been and what she's currently working on?
Hi guys, nice to be here again. I feel like I'm becoming a little bit boring on these collabs just because it's a bit of the same old same old sort of O-1 O-1, EB1, an L1 renewal. Nothing too out of the ordinary this week. One interesting situation I guess that came up was I was speaking to John and a few of my other colleagues about this was a someone had come to us asking to U.S. passport for their child that was born abroad. Uh, One of the parents is a U.S. citizen, so that's something that we've been
Yeah.
looking into. It's a bit of a unique situation. I don't know how much I want to go into it, but it's not as straightforward as it seems. Because typically it can be fairly straightforward if you register the birth at a consulate, but this one's a bit unique.
Well, that's the great thing about being lawyers, right? There's nothing that's open and shut, and why you kind of need us to solve problems because this was a situation. This is a client we had 13 years ago, right? I love when they come back, and they had this guy was he had a partner but not a wife in a quasi Russian country. What I mean by quasi Russian, it was one of the stands, um, and it was in a rough place. And so his partner and he had a child, and he's been with the child for the child's entire life, but been going and coming. He was actually in Russia. She was in this other quasi Russian country, and there were issues in getting in and out. And the deal is because they were never married, it made the case tougher for him to be the father. And in this country, if he was listed on the birth certificate, it would have caused major problems for her for whatever reason. That's how the facts were delivered to us. Whether that's true or not, we don't know, but that's what he said. But so he's not on the birth certificate, but he's been around the kid the whole life. The kid's now 6.5. So the general rule is if an American has a child outside the United States, then they can register that child as a U.S. citizen as long as they do it within 7 years. Well, here they are within 180 days of that time, and it's complicated by the fact that the American citizen is not on the birth certificate, nor is he married to them. So it's going to be all about proof. Was he really the parent? And he like bought her a house, and whether or not and it's in her name. How does he prove he paid it? He sent her cash. How does it prove that he sent her cash and she got it? All the complicated things you could have, right? So love cases like that because they're challenges, right? It would be easy if they said, "Hey, I have a kid with my wife and we're in France. What do I do?" We'd say, "Go down to the embassy and register." But this one, we're going to have to be lawyers and figure out a way to prove it. So I love it, Zoe. That's why we do these conversations. It's neat to figure out how do we solve these things when they're not so easy.
I love it. Well, thank you, John. Thank you, Zoe. Why don't we welcome our two new guests, Waleed and FJ? Thanks, guys, for joining us in this week's collab. Waleed, would love to know if you'd like to share with us what you're working on and how your week has been. Just heads up, we are live streaming right now, so feel free to introduce your practice if you'd like.
Hey everybody, my name is Waleed Nasser with Nasser Immigration Law based in Chicago, Illinois. My firm tries to focus on immigration litigation for delayed and denied immigration petitions and applications. But we do a little bit of everything, some family-based, some naturalization, a little bit of deportation. Um, this week, let's see, been working on has been a little bit slow. I've been traveling, so I'm not in the office, but working on a family-based case, naturalization case. Um, so nothing too exciting. But there was some news in the litigation world that kind of came down today. There's a
What's
big
that?
case in the Ninth Circuit called Munoz,
Mm-hmm.
which you might have heard of, John. Basically, it was
No.
it was a challenge to the doctrine of consular non-reviewability, which basically says that a decision of a consular officer in a visa application is final. Um, Immigration lawyers have been able to carve out some very small exceptions to that. So if an immigrant visa is denied for the spouse of a U.S. citizen, you can challenge that denial in federal courts under very few exceptions. And the Ninth Circuit affirmed those exceptions, but now the government has filed a request for the Supreme Court to overturn that decision. So they're trying really hard to shut the door to federal court oversight of consular officers. So
I
we're going to see
like
how
this.
that one plays out.
I like this a lot because this goes along with we talked about a few weeks ago was Chevron, right? And the Chevron I can remember from law school was agencies are given such wide berths of discretion, and there's sort of a debate going on between the courts and the agencies, right? Remember, the agencies are the executive branch. The president or through the president's people will appoint a person ahead of that agency, and that agency makes decisions within the purview of it. So in our scenario, it's under Homeland Security, we have USCIS, and we have the State Department, a different agency. Both of them are dealing with immigration. So this is all about whether the State Department has almost full discretion to make decisions with no one being able to review it, right? So here's the cool thing about this. They could have accepted their really tiny exceptions, which are really tiny. And in my opinion, it's incorrect that they have such wide discretion where they can't be questioned. I think the great thing about law is that if you do something, you make a decision, then you can take it up to somebody else that can see if your decision was within the law or not, right? I mean, that's what a fair nation does. And what Waleed's saying here is for consular appointments, if they say no, that's it. So what he's telling you is in the Ninth Circuit, so that's a San Francisco, Northern California circuit, so usually liberal judges, have upheld that these narrow exceptions, and what he's talking about when he says immigration of married to a U.S. citizen, that isn't just the immigrant that is having their case determined, but a U.S. citizen and their right to have their spouse with them, right? So this is the U.S. citizens' rights that are now in play in this as well, and that's why that exception is there, right? Because Americans are being involved, not just foreign nationals who aren't citizens and can't vote, right? So what Waleed's saying is that the Ninth Circuit did this, and USCIS, I think it's a big gamble, right? Is taking it to the Supreme Court, which is a court, right? And asking that court to say courts don't have the right to look at agencies' decisions, right? So courts are going to look at this in a couple different ways too. There are going to be people that are the way the judges have philosophies, right? So there's sort of broad thinking judges that look at the spirit of a law, and then there are firm, strict constructionist judges that like, hey, the law says this, that doesn't give us the right to do this outside of that, right? So I think, Waleed, this is fascinating. This whole Chevron concept, which is now going into this, is whether or not courts can question agencies, right? But you're asking a court to make a decision, right? I like our chances that the courts are going to say, wait a second, guys, your decisions have been all over the place. They're not very fair very often, and you're just telling us to trust you. Well, we'll trust you, but we're going to trust you more if we can question your decisions instead of you just saying whatever we say goes. Love that you brought that up. That's a fascinating thing. I was not familiar with it, but I think that's an excellent thing for us to talk about in these collabs because we don't always talk about the forests. We get caught into the weeds or the leaves of the trees here. So thank you very much for bringing that up, Willie.
Absolutely.
Thank you, Waleed. Awesome, FJ. Welcome. Would love to ask you the same question. What you've been working on and how your week has been looking like. Would love to know.
Good afternoon, everyone. Sorry for joining late, but I'm here. Yeah, we have a very interesting case where we have an individual hearing that was rescheduled many times in the past. It's an asylum claim that was referred because of relocation, and we thought that we have a very strong case. So we filed our legal brief and eligibility, and 15 days before the hearing, we received a notice from the trial attorney the chief counsel's office saying that they're not going to appear, right? And they kind of stipulate and take part of the it's part of the prosecutorial discretion where they're not going to show up, and they kind of agree to the relief sought, and but they're still saying that it's still on the immigration judge to decide on the merits. So what happened during the hearing was we just presented the client, the respondent, regarding the eligibility very briefly, and the judge have some questions, and she granted the case. I mean, part of the notice from the trial attorney as well was that they're not going to appeal, right, if the judge will grant a relief. So that's a very good way of streamlining, the issues, and instead of doing kind of like full blown trial during the marriage hearing, which usually takes about three hours, right, or more if there are interpreters. Now the hearing only took about less than 30 minutes. So that's really good for practitioners
Congratulations.
to kind of file your brief, and also the issues, discuss the issues, and hopefully you'll get the same response from the trial attorney. So that's what practically happened to me this week.
Well, that's great, FJ. It brings up an interesting point. How often does immigration actually fight when you litigate, right? So we've all had heard of examples, and many of us have seen. You file your federal lawsuit, a complaint against USCIS for maybe denying your I-129 or your I-140 or things like that, or even a writ of mandamus to force a consulate to make a decision on a case that's been pending for a ridiculously long time. And sometimes they just reopen and give it to you, right? What I think you've talked about this, Waleed, and I'd like to chat more about it, is when USCIS fights. Have they become more aggressive in defending themselves? Are you seeing any trends on the litigation side? And if I can make a suggestion, your camera's a little high, so we can't see your whole face. Yeah, thank you.
Sorry
Can
about
you
that,
can you
John.
tell us a little bit about what you're seeing trends in litigation for as USCIS on this, and any even types of litigation? I think would be helpful, because FJ is an example of what we were talking about. But how prevalent is that right now?
Now,
So
now,
I,
sorry, go ahead.
yeah, so I know FJ was talking about immigration court,
He
but
was, right, with an asylum case.
Yes, immigration court, immigration judge. So this was denied by
Mhm.
referred by asylum office.
um, but I think in the federal court context, we have there's some positive trends and some negative trends. So consular delays are on a real negative trend right now, especially out of DC. And DC is like the only place where people can sue if they, are pending most non-immigrant visas, because there's no that's the only possible place for venue. So
Right.
I've been seeing, some cases that are delayed by for 4 years, in administrative processing, get a motion to dismiss. They're trying to hide behind the doctrine of consular non-reviewability, which is what we talked about earlier.
Mhm.
Um, so that's
Could you?
they've been fighting those tooth and nail, consular delays.
Mhm.
But lately, I've been filing a lot of mandamus for delayed bona fide determinations for U visas and delayed EADs for U visas, and those have just been getting granted left and right. So
See, that's what we needed. That's the info.
yeah,
Thank you for
No.
that. See,
yeah,
these nuggets, these little gems that pop up with these conversations are
yeah.
fantastic. I love that.
So
And
if
and
you have
again,
a if you have a pending BFD that you need, now's a great time. Now's a great time to sue on that, and also pending asylum for 4 to 5 years or more. Those are getting interviews. Those are good trends, but consular delays right now, no bueno.
so let's talk civil procedure for a second, going back to that fun course that we all had a million years ago. Venue, right? So you're making the statement that the only venue for a consular denial is Washington D.C. because the consulates are outside the country, and there's no U.S. federal court that sits in Rome, Italy, that would be able to deal with a denial by the Italian court, or I'm sorry, the U.S. Consulate in Rome, right? is there any way, because venue is based on ties, significant ties to the venue, right? What if somebody, for example, had a job offer in Dallas, Texas, or San Francisco? We talked about certain courts are more liberal on immigration issues than others. So they had say that it was a, Google had offered a job to this software engineer from Hyderabad, India, and the Hyderabad consulate is sitting on this forever. But the visa has been petitioned by Google, who obviously has ties to the Bay Area, right? If that's where this particular job's going to be, could they bring it into that venue because of their ties there, even though the consulate that made the decision was there, or is it because they're suing the State Department? And unlike USCIS, which is all over the United States, the State Department may be only limited to Washington, D.C. Has there been litigation on the venue element of that?
I think so. And this is kind of like a law school exam question.
It is, right?
Here, John. But
Yeah.
I think that you could do that. I think that you could make the argument that venue is proper in where the employer sits.
Mm-hmm.
But you have to remember that a DS-160 and a DS-260 are, they're tied to the applicant. They're vetting the applicant's eligibility. So like the underlying I-129 or whatever, I-130, whatever, I-140, whatever it is not necessarily related to the visa application. So there's an argument that can go either way. And I think what they're trying to do kind of in concert is to just make DC like the one-stop shop for like visa delay cases, because the case law there is so hostile. So I think that they're a coordinated effort to try to move everything to DC to try to get all the cases there and just challenge venue. And it's really up to the lawyer at that point, because do you want to fight a venue battle and lose, and no client wants to pay for fighting a venue battle.
I think it would have to be a strategic decision by probably attorneys that do a lot of this, that would have a lot of cases, to say, look, our cases are being delayed 4 or 5 years. If we go through DC, let's take a battle. We know there's a friendly judge who's going to make the first call on it, right? So some district court judge, say in San Francisco, is going to say, I think I have venue here. I think I can hear this case. And then the U.S. attorney is going to try to remove it, but they're going to have to make the decision, right? That district court judge is going to have to say, okay, remove it or allow it to be removed, right? So I think it's an interesting theoretical battle and a strategic battle. Like if we can't find relief, and the whole reason to bring mandamus cases is because it's taking so long. So if you can bring it into court and then the court date's 4 years, why bring the mandamus case? So you're going to lose anyway. Why not take a run at a court that might entertain this and see what happens? So look, just again, it's very theoretical, very law school. And I don't think I ever had any fun in law school, but this is sort of fun to talk about. So thank you.
You never had any fun in law school?
I had no fun in law school. It's a horrible situation. It's just nightmares all the time. And I think I've just planted in every lawyer's head, some sort of nightmare that's
trauma.
Some trauma that will probably keep you up tonight. So apologies about that. FJ, you had some statements you're saying, and I apologize by conflating the difference between immigration court and federal court. I did conflate that just because I wanted to see what Waleed was going to say on some things. But you wanted to make a comment on something.
Yeah, no worries, John. So what I'm saying is, I think as Waleed was saying, the most common issues that we're facing right now is actually delays. Right, they're taking decisions forever. But with regard to the merits of a case, once we file a lawsuit, like a mandamus case, the government attorney, the oil attorney, usually like, okay, just approve the case. So we see these trends now. But I'm going to ask Waleed, so for the consular delays, how long was the, before you can file, or in your cases, in your experience, when do you say that I'm going to file a lawsuit, like for those delays?
So if it's a consular delay, I think all pre-interview delays are going to get a motion to dismiss.
Mm-hmm.
because the Department of State is maintaining that it's a first in, first out. Everyone is in a long line, so it's not fair for someone to jump the line, no matter how long the line is. They're still
Mm.
saying COVID if it's a pre-interview delay. Okay, so I honestly I wouldn't recommend filing a pre-interview delay if a client came to me and wanted to do like a pre-interview delay case. I don't know if I would do that one, even though I think that some embassies are like their interview wait times are just absolutely ridiculous. And I was talking to some people about maybe filing a mass plaintiff action against one embassy in particular in Islamabad, very, very slow. Um, but I think that a post-interview delay, it really just comes down to like the length of admin processing. And I think that on that, you kind of look at it on a case by case basis. There's a regulation out there that says that, admin, like an applicant has to submit the required documents after admin processing within 1 year. So I think that the government is like taking the position that, they have 1 year of admin processing to complete everything.
Mm.
So, but before, like a couple of years ago, when we file like I could file a case that was an admin processing for 1 month and it would be resolved. You know what I mean?
Yeah,
Now
thank
we're getting pushed back on 11 months, 12 months, 4 years. Like I said, like another attorney consulted me about they just got a motion to dismiss, and it's been 4 years, and it's a very sympathetic plaintiff. Like his wife died while they were waiting for the visa interview. You know what I mean? And they still got a motion to dismiss, and so
Yeah, thank you for that.
y-
Very quickly, yeah, pre-interview, I think our hands are tied. I mean, they can just say that people are
Easy defense.
waiting. Everyone is waiting, and based on my experience, I have done my cases on with the firm where we
mhm.
do a lot of Manila cases, where for preference categories, from the time the case was documentarily qualified up to the interview, so it looks like it's from 2.5 years, like 2.5 years to about 4 years
In
before you get
Manila.
the interview. Yeah, for immediate relative, it ranges from 3 months to a year. For
Wow.
employment-based cases, that's already available. I see a trend that it's like less than a year to 2 years. But of course, these are kind of personal experience with the firm, so that we know how to advise client when they ask us
Hmm.
where's our interview, right? So at least they don't publish, a processing time or when do we expect the interview, so we can just rely off, our personal cases. So that's that.
There was some really good data that IRAP, International Refugee Assistance Project, came out with. It was all over AILA. Basically, they FOIA'd, or they got in discovery, or like some FOIA litigation, like a bunch of data about like interview wait times,
Mhm.
and NVC like wait times and stuff like that. It's out there somewhere, and it might be helpful. Um, Otherwise, I think you're right. I mean, basically, they're gonna just say that it's everyone's in the long line, and you have to wait for that. But admin processing, I think there's much more of a fight there. Basically, I think what lately the government's been saying that an admin processing decision is a refusal, which is final agency action barred by consular non-reviewability. So you got to be careful with that, and you gotta fight. The courts are pretty split on this. I think immigration lawyers like us, not the government lawyers, are winning on this issue.
Mm.
That a 221G is not a refusal.
Really?
So
Because they say
yeah,
it
I
is.
think
That's fantastic.
they
It's
say
not.
that they say it is, and I've got a
They
couple of
operate as
responses
if
out
it's a
there.
denial. Yeah. They,
Yeah,
they they say it's a denial, but we're still adjudicating it, which is weird. It's a misnomer, right?
it
It's the
doesn't make
wrong
any sense. Yeah.
definition to say it's denied, but yet we're still looking at it, right? They,
Hmm.
they should give it a different term. But I'm with that. Can we shift over this? We could talk about litigation all day, and immigration has so many different prongs. I really wanted to ask Yesh, what is she seeing on RFEs in this second wave of the 2023 cap season? What are you seeing, Yesh?
Ooh, great question.
Well, good morning, guys. As far as RFEs, a lot of what we're seeing right now is USCIS is asking about employer information. That seems like a very common one, a common theme that I'm seeing. Just asking to see, where the office actually is, where people are working out of, um, just what your lease documents look like, show us photos of the, workers actually or your employees actually in the office. And I know we were discussing about this earlier. It just seems like they're trying to set you up or set up um, or
The
open the door to
revocation.
come in
Yeah.
for a site visit, which is
They're
a lot
looking for
of,
revocations, right? I mean, that's
yeah,
been interesting about this administration is high approval ratings, right? I think I saw 83%. I think Trump was around 60%, and that Obama was around 79%. So more approvals than Obama, but the site visits, the
for
fraud
more site visits.
investigations are much more. And the
Yeah.
questions in the RFE are to set up revocations. And so one of the things you and I were talking about was we'd seen in L's before, this doesn't comply with Vibe. Can you tell us what Vibe is and how Vibe has now gone from L's into H-1Bs?
Vibe. Oh, I'm sorry. I had like can't remember off the top of my
Don't
head.
worry about the acronym. What
Yeah,
Vibe
I was like, where is it?
is something
Um,
like verifying something about businesses. That's not important. But what is Vibe and how is USCIS using it in the H-1B context?
So Vibe is actually connected to D&B database. So where each company would go and register onto their database, and then USAIS kind of checks on that to see if you're registered, to see kind of figure out if you're actually a real company. Is it real?
Yeah.
And so that's if you're not on there, then we're getting this RFE where you're not, where USAIS says we can't validate you on their system, and so now show us proof that you're actually real and you're actually
Yeah.
doing business where you're claiming to do business.
Yeah.
Um, and so that's kind of in a nutshell. To be honest, I have tried getting into that website a couple of times,
Yeah.
and I am amazed at how difficult it is to get in there because it's always down. So if you
Yeah.
guys see any, yeah, if you guys have any other, if, any tips to get, your clients registered on there, please let me know.
No, it's exactly right. And if I can build on this a little bit. So what I was talking about is we've seen for years in the L1 context, which is an international company that has a relationship with an American company, right? So it's either a parent subsidiary or it's an affiliate, and then they're transferring over executives or managers or specialized worker. That's the L1A versus L1B. So what they always would do is on their RFEs say, hey, according to the Vibe system, you don't appear to be have the relationship you're saying you're going to be, right? So then you're like, I can remember the first time I'm like, what the hell's Vibe, right? So if you Google Vibe USCIS, you'll see that it is an acronym for something, but D&B is Dun and Bradstreet, right? So Dun and
Yeah.
Bradstreet is they give a D&B number and they give a rating, right? Like your credit score for companies is what D&B gives you, right? So USCIS has empowered Dun and Bradstreet to tell them if what these companies are, right? You don't always sign up with them, but on their website it says you can go in and you have to be the client. Go in and update your record. So if we see this, you would send your client in and go, hey, make sure that that your registration indicates that your international company is related to your American company the way it is, because it's not picking it up on its database, because it's imperfect, right? Now we've just recently seen, right, saying that these same Vibe analysis under the H-1Bs, and what they're doing is they're trying to figure out, are these real companies, especially in the staffing realm, right? Like you say your address is 123 Maple Lane, but Vibe doesn't say that. Okay, then you're like, what the hell is Vibe? I told you it is. Here's my leads, right? So that's kind of how you have to do it. So you go to Vibe and see if you can update it. Then you just go, look, here's my leads. And one of the things that's really interesting, as we were talking about this going back to law school, the law is a web, right? So things that Waleed and FJ are talking about in litigation goes to non-immigrant business immigration, and the fact that if you're denied, you sue, right? So you think about that as the end zone, and this is the 1 yard line. But what you can do is take L strategies and move them into H strategies. So where L's have traditionally looked at the structure and size of companies, H is it's new. So this is what USCIS does. They go there and they have a new toy, vibes their toy, or a new strategy or a new analysis, and then they come in and they hit you over the head with it. And attorneys are like, "Oh, this is the toy of this year. What are we going to do?" Okay, so what Yesh is talking about is we have a new approach from USCIS on H-1Bs, and that is questioning the company. Now, think about this for a second. Immigration has made lots of changes over the years where if somebody was an illegal worker, they would then find that worker, deport that worker, right? Then somewhere around the Bush administration, they started doing gotchas on companies. And it's evolved over time to now companies are becoming the focus of immigration wrongdoing or whether there's immigration wrongdoing. So what we've seen right now with the double registrations and H-1Bs and how we're seeing H-1Bs attack the companies is USCIS said, companies, we're concerned about you too. And they're coming at them in new, interesting, unique ways. And us as attorneys have to be ready to defend our clients. Even if our client is one that we registered or did the visa for, or in many instances, they get tired of the attorney that didn't know this thing and didn't see it coming, right? So they hire a new attorney and go, "Here's my RFE. Can you answer it?"
Answer.
Right. So that's kind of where we are. And so what? Yes, you've done a great job. Is what are we doing? How do we prove that a company is real? And so take us a little bit more on what are some other elements? What are some other questions USCIS is asking regarding companies in the H-1B context?
Well, I mean, they're essentially looking to see, if you're filing for, they're going back 3 years, let's say, where I had an RFE where they're going back 3 years and they're saying you had these many number of petitions that you filed for. Now, you only seem to have, according to your, documentation, you seem to have your address at one location, and we've reached out to those landlords or the company, that the property management company at that location. It looks like you only have 1,000 square feet, and you have, over the past 3 years, you've had 100 petitions, let's say. How
Right.
are you fitting all of these in there? But I guess they're trying to, they may or may not realize that all of those petitions may not have been approved, may not have come over, or have come over and transferred. Like, people change jobs every day. And so now you have to, I'm asking my clients to go back and dig through all of their W-2s, their tax returns,
Yeah.
any payroll records, to go back and say, tell me what happened to each and every person, and give me details about when they started, when they left, when they resigned, all of that, just to answer these sometimes ridiculous RFEs.
They are. And I posit this. I don't think they're confused. I don't think USCIS doesn't know and it wants you to help them understand. I think they are positioning to attack companies on the basis of fraud and revoke visas on that scenario. And what you just described is interesting. So they have now got a better computer system. That's what this means.
Yeah.
And their computer system is they're going back and they're saying, for the last 3 years, you filed 100 H-1Bs. Yet you said that you have less than 25 employees, and that's why you did an ACWIA fee. Guys, if you don't know this, on H-1Bs, if you're less than 25 employees, you pay a fee of $750. If you're more than 25 employees, you pay a fee of $1,500. This is in addition to the I-129 fee. Don't mean to get in the weeds on this, but some of these RFEs are like, well, you've applied for 100 H-1Bs in the last 3 years. How can you be less than 25 employees? Implying that you're lying to them, right? Or the other one is if you're more than 50 employees and more than 50% of them on H or on L's, then you're dependent, and that fee goes to north of $4,000 as a filing fee, and you have to comply with all sorts of recruitment statements, right? So USCIS is coming with these things based on your history of applications to then imply that you're not telling the truth of how many employees you really have, right? So it's forcing employers in their RFEs to give them more information, right? So they're going back. So really all USCIS has when you file an H-1B is an LCA and an I-129, right? That's all they have. So what they're trying to do is find more data, and they're using the RFE and the site investigation and the consulate appointment to get more information to build bigger databases on companies for the purpose of revoking visas, right? So as attorneys, we're in this interesting thing, and we've watched the evolution of this a couple of years. It's like, oh, well, let's just give them what they're asking for. Or our client's like, wait a second. The more you give them, the more they have, and we don't have an obligation to give them. Matter of fact, we don't even have to answer a site investigation. Their website says it's a completely voluntary process. So you can say no, but the reason you don't always say no is they can trip you up. So your H-1B goes to the consulate. The consulate says, we're going to 212G this one and wait. And Waleed's going to try to sue us, but we'll back it up for 4 years. So yeah, good luck. Why don't you just go ahead and give us all this stuff that we're not entitled to so that we can build a bigger knowledge base on who you are. And the bigger the knowledge base we build on you, where we can find inconsistencies. And if we find an inconsistency, we're going to go ahead and jump to the conclusion that you're lying to us on the amount of employees you have, right? So we're going to deny your visa or ask you for a $4,000 filing fee, right? And that's where I think they're not dumb, right? I think they've gotten much more aggressive in their requests for things, and really interesting in their approach. They're not
A little bit creative.
Yeah, they are creative, and they're intelligently creative, and their job isn't merely to take what you give them and make a decision, right? We find them Googling more, right? They'll never Google to help you win a case. If there's a negative takeaway, if they Google, they're not going to go see, oh, you didn't tell us that they did these other 5 achievements. We think they're going to get an O-1. You'll never see an RFE that says counsel didn't give all the evidence. Here's some more nuggets of great evidence to make the case. The only time they'll Google is to say, we think it's insufficient. And their fun term of art is according to publicly available information, right? That means my Google research tells us that, you're not really at this location, you're at that location. Or this person that you said was a software developer is really the CEO, and therefore you're not paying them the prevailing wage, and you're lying to us, and we're going to make a finding of fraud or deny your case or whatever they might. So fascinating, turn on H-1Bs, just in the last couple of weeks. And I wanted to take that, and I wanted to talk to Zoe about O-1s for a second, but I wanted to go back to Waleed if we could. And I told you I pulled it out of litigation.
Yeah, let's do it.
Have you seen any litigation on double registrations yet?
Not double. I don't think double registrations. So I know Jonathan Wasden, whom you know, John, is doing some stuff about the fraud findings.
Yes.
But as far as double registrations, like multiple employers or the same employer filing multiple registrations for the same beneficiary, I have not heard of that going on.
Yeah, we're looking at one. John is going from a perspective, really interesting, right? Because John's the counsel, or the IT Serve Alliance's general counsel, right? So he represents companies, but he is being very precise in how he's going at it. And I think he's giving USCIS some grace. Not that he likes them. He pinged them hard, but I think he thinks a better case is the findings of fraud in these H-1B things. They're finding against the beneficiaries, right? Without any analysis of whether the beneficiary did anything, right? So if there's a double registration, company A registers for a beneficiary, company B goes for the same beneficiary, and the beneficiary may or may not know about it, but they're not even analyzing that, right? So the beneficiary could know about it. They may not know about it. They may have instigated it, but they're not doing any analysis. But they're finding that fraud against that beneficiary, which then lasts for forever. They go to a consular appointment for another company on an H-1B. They're going to well, there's a finding of fraud against you, right? And this goes to Zoe. How would you deal with that? What waiver, if any, would eliminate this finding of fraud that nobody ever determined? And the determiner of it was USCIS, by the way. Now you're at the State Department. and State Department tells you, I can't give you this H-1B visa because USCIS, another agency, found that a case that was filed on your behalf was fraudulent. How is there any process to remove that finding of fraud in front of that consulate?
It depends on the circumstances, but I can't think of any waiver that would just forgive that right off the bat. The only sort of waivers that I know of that really exist within immigration they're all based on if you have an immediate family member who's a U.S. citizen that is going to sponsor you. But in that situation where it's like an employment situation, I don't think any exists. Waleed or FJ, you can feel free to jump in if
I was going to ask those guys. What do you guys think?
If I may, John and Zoe, actually, if I were confronted with that situation, I would argue number one that there's no fraud on the part of the applicant, right? So that he's not
Right.
going to file any waiver. But for non-immigrant visa cases, the waiver is 212D. John, I know you heard this one, which is very liberal compared to a immigrant visa 4601 because you have to prove you have to have a qualifying relative for the extreme hardship, right?
yeah.
Right.
So for a non-immigrant, you don't need to have a qualifying relative. There's a very uh, there's a decision which I, the top of my head, I just can't remember, that says that as long as you are not a threat to national security, right, you can file the D3 waiver, which is very liberal. Most of the time, they will grant that. So
Really?
if in case confronted in that situation, my first thing to do is argue that it's not fraudulent or not material misrepresentation, and then just file the 212D waiver. Thank you.
So let me take this, and I want to bounce this from you, FJ, to you, Waleed. Okay, so we make the 212D waiver in front of the consulate in Hyderabad, India, that we didn't commit fraud. There's no facts that I did anything, had anything to do with this. And then maybe even throw in the argument is another agency made this determination, not the consulate. But then the consulate still says, you know, we're denying that. And then I would assume they'd argue, Waleed, that consular discretion is absolute. And there's nothing you do about it. Is there any federal lawsuit to bring against a consulate for utilizing another agency's determination, which didn't have any facts that led them to the basis that this beneficiary committed fraud, other than the word that another agency did it?
Yeah, that's a really good question. I never confronted with questioning the decision of the consulate relying on the finding of fraud another agency. But my strategy in that situation, John, would to go to the Department of State Legal Net. Since you're questioning their authority, it's question of facts and question of law. They are very responsive when it comes to the embassy's wrongful determination or refusal of a visa. In that situation, as I said, the legal net is your issue go through. Uh, to,
Thank you, FJ. But I want to ask Waleed a question on this. But Waleed, hold 1 second, because I learned about LegalNet on these collabs. Never heard of it, never used it before, and we tried one, and Zoe and I teamed up on it for a denied. Was it a TN?
It was an
these,
issue.
it was an E2, and let me lay the facts out and what LegalNet did, and I don't want to put all of the eggs in the basket of one data point, right? But here's our LegalNet, or my sole LegalNet experience that I enjoyed with Zoe. Okay, so we had an E2 where this guy had significant ties to his home country. He was Canadian. He had property there. He had a company there. He showed he was making money there. And he goes into the E2, and he'd been denied. So he goes back in and he offers all these ties to the home country, because the first time they said is you didn't have ties to your home country. So we sent him back in. So he goes, look, I've got this big package of materials that I have ties to my home country. And they said, we're not going to look at that. They then denied it. And they said the basis for the denial was no ties to his home country, right? So it was horrible facts. So we went to LegalNet, right? And Zoe, why don't you come in? What did we asked him, and we told him it was about the home ties. Tell us about it. Tell us about our experience with the legal net on that.
I mean, we had explained the situation. I separated the package because one of their instructions was to, don't have an upload more than 1 MB. So I separated everything into like a million attachments, sent it to them, and I don't even think they read it. I'll be honest with you.
Well, that conclusion is a good one, because they came back and they said, we agree with their decision that the amount of money invested wasn't sufficient, which was not, number one, wasn't the question. Number two, the money was substantial. And number three, the reason they denied it was no ties to the home country. So then we went back to him and said, wait a second, I think you got this wrong. It's really the home ties to the country. And the reason we're coming to you and we'd like you to weigh in is because we'd like you to provide assistance to us that they will look at the ties to the home country. And by the way, here are the ties to the home country, so you can see that we're not making this up, right? Property, business, money, all this sort of stuff, right? But yet they just declined to weigh in, and we felt that it was a weak solution. And part of that, I think, goes back to Waleed's point, is because the consulates don't have to go to court. LegalNet's not a court, and LegalNet seems a little bit, in my one experience, and I'd like you to give me some anecdotes of examples where they've been good, is that they just didn't want to do it, right? I mean, they just didn't. It wasn't a strong organization that felt any sense of obligation, nor were they very organized or responsive to, one, the request, or two, the evidence in front of them. Help me share some examples of better experiences with LegalNet.
Well, that was my only experience with LegalNet as well, but I'm just, like I said, that was my only experience, but I'm assuming it's like any agency. Sometimes it's just going to depend who is reading it and who gets to look at it. And maybe they, looked at it at the end of their day, had a rough day. They probably maybe they got it confused with something else, didn't actually read the email.
I do have a good experience with LegalNet. That's why I'm recommending it. But there were denials as well, or refusal. But the thing with my cases were like reinstatement of a visa. Like, they terminated the visa for inaction, and we tried to reinstate it at the consulate, and they refused it. We went to the LegalNet, and they reinstated it. There's also a CSPA determination that said that the embassy says he's not eligible. Then we went to LegalNet, it was approved. John, in that situation, you can also try again, reconsideration, or something like supervisor, attention supervisors at LegalNet. They might still act on it. But I'm wondering what happened to your case. I mean, you just stop there, or you refile?
Zoe, help us on this one. What that was
the last correspondence I knew of. We sent another email basically explaining what we said, but very politely, which was, I don't think you read our initial email. If you could please take a look.
Did we find an ultimate resolution, or did our
that I know of? I think we're still waiting. That wasn't all that long ago.
It's back still. It's in front of LegalNet again, right?
Yeah.
Would you think refiling? So refiling is another option for you guys.
My personal concern with refiling anything in a situation like that is the evidence is going to remain the same.
Okay.
That's what my concern is. Like, what else can you show? So if it was denied on that.
Let's go to Waleed. Okay, so we assume LegalNet's not going to do anything positive on this. Waleed, anything we can do to sue the consulate for obviously making a decision? I would think it'd be arbitrary and capricious to say that somebody that and we had an affidavit, by the way, is I attempted to give them this package of ties to my home country. The adjudicator said I will not accept those ties to my home country. We went to LegalNet, who made a decision that wasn't related to that. Of course, we have all this thing, and then sue in federal court that the only justice we can find is going to be in a federal court, right? And that these guys aren't following the law. There's nothing we can do. They're denying us for the lack of ties to home country, and then won't look at the ties to home country. And by the way, Exhibit A, here's the ties to home country, and they're significant. Anything we can do in court on this, or are we out of luck?
Yeah, I don't think there's anything you can do on this one in court. That one's going to be pretty clearly barred. Review is going to be barred under the doctrine of consular non-reviewability.
Right.
And it's really sad that you know, that this is what what we have to deal with. Like, you know, like literally as immigration lawyers, like we're all professional, you know, we're all, you know, intelligent or highly educated people, but like part of our consideration for our clients is that maybe we should just refile and hope we get someone with a better mood that day. You know what I mean? And like that's a valid strategy. That's a valid like legal strategy, you know, because we're just so used to dealing with the arbitrariness of like consular officers, you know, that we're like willing to undertake all this expense and time and energy for a shot to have like a reasonable shake, you know, at like, you know, our case getting approved. But like maybe what was said earlier about like, you know, requesting reconsideration with LegalNet, but from my understanding, I think LegalNet doesn't really like deal with factual issues. Like if it's just a question of fact, like they deem the evidence not sufficient, you know, then that's probably yeah. I've had one positive legal net experience. There's actually a client of mine who I did a lawsuit for, but then the immigrant visa was denied. She went to another lawyer to do a legal net inquiry. Basically, the embassy denied them for misrepresentation because the guy had come in the past on a visa called B in lieu of H, which I had never heard of before that time. And he yeah, and he
They don't work anymore, but they used to.
yeah, and he enrolled. He was in there for 6 months doing like some temporary thing, and he enrolled his daughter in school, which was okay. And then basically they said that he like misrepresented himself because his daughter was enrolled in school, and there's like this encounter with CBP. Ultimately, it was like they made a legal mistake, and LegalNet was able to overturn that like quickly. So I think when it comes to like clear legal stuff, like the CSPA stuff and this kind of stuff, but when it comes to just basically the officer's analysis and their discretion, I think they're just never really gonna. I don't think they're gonna touch that. But if you really do want to sue, like if you want to sue, you never know. You might get a U.S. attorney that's like, hey, maybe this is some BS, you know, and you know, and so that's always an option too.
Once again, not, you know, the greatest legal minds concept. It's just like, okay,
Yeah.
we're going to go above your head and we're going to bully you, and you're going to have to explain yourself to some U.S. attorney who's going to go, what are you doing, man? Why you didn't let him look at it and you denied it based on that? Come on, don't make me go to court on this, right? Some judge is going to yell at me, counselor, are you seriously defending this? But what that lawyer would then say is, Your Honor, it doesn't matter what they said or didn't say. There's no reviewability here. I mean, I don't have to agree with the law, but that's what the law is, and that's what it defended. And I think, you know, the interesting thing about that, if we could finance these all ourselves because we have a big trust fund and we want to just right the world's wrongs, and wanted to fund all of our clients' cases into really long-winded litigation, that's how you would get a federal court to say, wait a second, this non-reviewability has to go, because what's happening is there's too much discretion and people are breaking the law, and they're just saying, I can break the law, I'm above it, because nobody can question what I do. And that's what's happening in this case, right? I mean, this is an open and shut E2. This guy has invested significantly more money than he needs to have. He's got ties to his home country. There is no reason to turn it down, and they can't come up with a reason. They're just doing it, and they're saying nothing you can do about it. And
it's bold.
It is.
It's just ridiculous, you know. Like that's what the APA is for. I mean, the law says that you know, government officials can't act arbitrarily. But now it's just like it's just so crazy. And by the way, I did want to mention one more thing as a potential solution. So I'm part of this group. Actually, it's like of immigration litigators that are trying to overturn via like, you know, small steps in litigation, the doctrine of consular non-reviewability. And there are some couple of former consular officers in that group, and we meet up once a month. There seems to be a lot of like back channeling that goes on, and it's kind of like a fraternity with these like consular officers. So there's this one guy on there. He charges like $500 for initial consultation, like something crazy. Okay, but like he gets stuff done through like this back channels. Like apparently, you know, he used to be a consular officer. He worked in Mexico.
Like knows a guy type of thing.
Yeah,
Yeah.
Oh my gosh.
And apparently, and there's a whole company now called Argo that's like based in South Carolina. I don't know if you guys have heard of them, but they're essentially all former consular officers, and
Mm,
they charge something like $800 an hour. And
not the problem.
but like apparently there's like this huge, like, it's kind of a known thing, I think, that like once a consular officer, always a consular officer, like kind of some sort of like fraternal
Oh my
like
goodness.
type of deal that they got. Yeah, I don't know. But maybe that's a route too. Like if you find someone who is really
Well, you know,
in
what
on
would
the
be interesting is if you want to talk to your guys, this would be a good test case on this issue, right? I don't know how much my client would want to shell out for litigation, but
yeah.
if there's a group that wants the right facts to get them on consular non-reviewability, this one's ridiculous, right? And the fact that we've gone to LegalNet and it didn't work, we're trying everything we can, and there is literally no justice on this, right? There is no place this person can go. And I love arguing those facts in front of a judge, right? The law is against us, but this is how you change law: is you get a really egregious fact pattern, and then this judge is going, and especially if a U.S. attorney is going to be arrogant and say, doesn't matter, we can do whatever we want, Your Honor, and there's nothing you can do about it because of consular non-reviewability. That's what they'd have to say. And they can say that as sweet or as harsh as they want, but some judge is going to go, why is that? So I think the question would be finding the right venue and jurisdiction to bring that in front of a judge that says, I'm not a strict constructionist. I know the law says that, but laws are meant to be changed and they're meant to be just, right? And that's a fun thing. This has been a fantastic conversation, by the way, Pierre. We went a lot of places today, and it was almost scripted how we went from litigation into non-immigrant visas and what we do.
I loved it. I
What we
loved it.
do.
You know, sometimes it's really good to go off script and off plan.
Yeah.
We hopefully next week what we'll be able to do is I really with Waleed and FJ and a lot of the other attorneys with us to how the new features of Visas.AI look like. I think it would be great for them to see the transformation. But for this week, it was lovely to discuss, you know, certain things that just felt natural. Closing remarks. I'd love if any one of our attorneys would like to have any closing remarks. Otherwise, John, you can close us off today.
No, I'd love to hear everybody else if you got a statement or two.
Awesome. Yeah. Why don't we start with Yesh? Any closing remarks today? We
You're
don't
on
hear
mute.
you,
Can
but
y'all hear me?
yeah.
Okay, there we go.
Yeah.
Um,
Mhm.
I just love that a lot of the information that I heard from a lead or FJ, I feel like I could, from John, is I could use it to like the H-1B systems as well. So this is super informative and I enjoyed it thoroughly.
Thanks, Yesh.
Lovely. Thank you, Yesh. Zoe.
So, similar situation to Yash. I just love hearing other people's perspectives. I mean, immigration is already so niche within itself, but within immigration, I think we all do so many different things. I know what my day to day looks like doesn't look anything like what Yesh's looks like, and it's not going to look like Waleed's, John's, or FJ's, or anyone. So, hearing what everyone is doing and just getting their perspective on it. I mean that's what this is about, right? Like we're learning about other things coming together. So it's always fun to do that.
Excellent.
Glad to hear. Thanks, Zoe. And then FJ, over to you.
You're on mute, FJ. FJ, you're on mute, pal. FJ, can you hear us? I don't think he can hear us. Can we unmute him?
Yes, FJ, we need to. Yeah, we don't hear you. I think you're on mute on Riverside. There we go.
Oh, it's back to mute
Oh.
again. He pulled it off and it went back.
Sorry about that,
Yeah,
Pierre.
there
I
you
know
go.
it's already 10 o'clock. I was saying that I've been practicing for almost 20 years now, and I'm always excited to like and look forward to this collaboration. John, thank you for inviting us and having us. We learn a lot. I do a lot of family and removal defense, but learning from you for the employment base really helped my practice. Thank you.
Thank you, FJ.
Thanks, FJ. And then Waleed, over to you.
Yeah, I really appreciate this collab. It's been a lot of fun listening to what everybody's doing and different different things that are going on in the immigration law community. I think this is how we all get stronger
Yeah.
by talking to one another and hopefully the government shutdown does not affect all of us too much. That's what I'm hoping.
Yeah, me too.
Perfect. Alrighty, awesome. John, over to you. Thanks
Yeah,
everyone for joining
one
here.
last nugget.
You'll close us off.
Yeah, one last nugget. I did an O-1 strategy session using our platform right before this, and sometimes we get moved. And I got to talk to a young lady that has won some national awards because what she's doing with indigenous farmers in India. And she goes, "Well, I haven't made a lot of money, and something else that she just thought her case would be negative." And I'm like, this is a slam dunk. I mean, the UN has appointed her to deal with indigenous folks on food and agriculture. And what she's done, it's really neat, is she's gone to these people that are being completely ignored and found the way they make food and spices and packaged them and sold them to wholesalers and then over the internet. And she's getting them money so that they can get out of hunger and starvation. And it was just a breath of fresh air. Can't wait to do her case. And we had a lot of fun because she really didn't think she had much of a case, but going through each of the criteria, she nailed it. And the platform was great for that. And now she gets to go back and look at it. And I just thought it was neat how it all worked well. So on that parting note, hope everybody has a fantastic weekend. Look forward to seeing you again next week. And thanks, everybody.
Bye, guys.